morning, everyone. Thank you very much for joining us today. I'm delighted to be able to welcome in-person guests and esteemed speakers here in Canberra and from all over the world. If you're joining us virtually, you're very, very welcome. I'm Professor Sally Wheeler. I'm Dean of the ANU College of Law and also one of the university's Deputy Vice-Chancellors. So I'd like to begin by acknowledging the traditional owners of the land on which we meet in Canberra, that's the Ngunnawal Ngambri people, and pay my respects to their elders past and present. And I'd like to extend that respect to any Aboriginal or Torres Strait Islander scholars and attendees joining us in person and online. For those of you who are perhaps not from Australia, it's important to note that we meet on Aboriginal land to which sovereignty has never been conceded. There is no treaty, and that is and should be an ongoing debate in modern Australia. Today marks the start of our long-anticipated Public Law and Inequality Conference, presented by the ANU Centre of International and Public Law, perhaps better known by its acronym CIPL. And over the next 3 days, we're excited to present an intellectually stimulating programme which features more than 40 scholars addressing questions which are of really pressing political importance. This conference was conceived of in early 2019, and it was part of our plans to recognise the ANU College of Law's 60th anniversary as an entity, and the Centre of International and Public Law's 30th anniversary in 2020. And the conference theme emerged out of conversations we were having internally. Leighton describes them as corridor discussions at ANU about Sam Moyne's then recently published book, Not Enough: Human Rights in an Unequal World. The pandemic, of course, intervened. We postponed, deftly pivoting, I think, to align our conference with the following year's ANU's 75th anniversary celebrations in 2021. But here we are now in 2022 as things have rolled on, and things have altered dramatically for those of us in Australia and elsewhere. Many of our speakers who would have come to Canberra now join us online. And the pandemic, I think, has served to accelerate the continuing growth of global and national hierarchy. Insecure employment for many low-income workers, the disproportionate effect of the pandemic restrictions on women, and particularly women with caring responsibilities, are just two examples. And the salience of the conference theme, I think, is why our speakers have stayed with us and been so patient and so accommodating through many iterations of this event, 2 postponements, and now the challenges that are posed by trying to schedule a conference in multiple time zones. The problem of inequality is multifaceted, but the role of law in its construction, I think, is often underappreciated. Ross Dixon, who, along with Adrienne Stone and Peter Kane, who generously served on as an advisory board for the organising committee of the conference, Ross Dixon puts this aptly: inequality is a social and economic construct, but it's also a legal and political one. Law can define the standards for measuring success and failure in this context, but it can also create the institutional preconditions for worsening or ameliorating the problems of inequality. So understanding law's role in masking contingent social and economic inequalities as either inevitable or as part of legitimate hierarchies is an important feature of imagining and implementing alternative social visions. And so in this conference, we're essentially setting up 2 questions. How do public law concepts, institutions, and norms frame or contribute to political and material inequality? How can public law scholarship contribute to clear thinking about the set of problems associated with pervasive inequality in contemporary society? The speakers that we've got assembled for you, our audience, are a truly an august group. We are joined by some of the world's finest scholars whose work intersects in a variety of ways across the theme of our conference. We're opening in a very impressive fashion with 4 sessions, the first of which I'm going to chair myself, which is kind of my privilege as Dean. And it's a session on equality, constitutional challenges. And that's followed by the first of the first of 2 First Nations public law and inequality sessions, and panels on anti-discrimination and inequality, norms and institutions, and democracy and inequality. At the end of today, and I hope as many of you as possible can join us, although I realise that by then it will be very late in the day or early in the morning for some of our online audience. Last thing today, we'll have one of this week's highlights, the Geoffrey Saw public lecture, which is going to be done by Professor Megan Davis, and her title is Modern Australian Federalism and the Uluru Statement. Megan's lecture will be virtual, but we will set this room up so that those of you who are here in person can view it together, and it will be here in the moot court. I'd like to thank not only those of you who've joined us, but also Leighton MacDonald, Professor Leighton MacDonald, who's CIPL director, whose vision this is, and Leighton has not been deterred by global pandemics or any of those things. He's had his vision, and he has doggedly pursued that. And as well to the conference organising committee for efforts in putting this together. It's a fantastic programme. I'd also like to thank Ashley Rogue, Challen van der Valk, and Tom Fearon, who are the part of the back office, marketing, my office, etc., set up in the College of Law, and they really have gone above and beyond to sort out all practical aspects of organising an event like this, sorting out tech issues, etc., and I'm very grateful to them. And this is an in-person event. For some of us, this will be the first time we have been in a room at an academic event with this many people since the pandemic started. And, you know, we've got everything here. We've got 3 full days of fantastic, engaging presentations and discussions. We've got real catering that you can eat while looking at other people. We've got live music, and we've got a dinner tomorrow night. And for me, along with many of you, I guess, the most exciting part of this is actually reconnecting with other people and being able to have debate with other people. I hope your time with us is really good and that you enjoy it. If there is anything that you think we could do to make your experience better, do tell us. And we will try and get that sorted for you. So I'm now going to introduce the first session, and I'm going to introduce both speakers at the start of the session. They're each going to speak for 30 minutes, and that will leave us 30 minutes for questions. And we're going to take questions both from you, our in-person audience, and from our online audience. Our online audience can use the Q&A function in Zoom to ask a question. And that will be at the bottom of your Zoom window. There'll be a little box, Q&A. And Leighton is going to coordinate those online questions so that they are put to the room. Both of our speakers in this first session are internationally renowned scholars of constitutionalism. Their work is in equal measure rigorous, illuminating, and imaginative. And you'll find web links in the programme to longer profiles of them. So if I turn first to Professor Julie Sook of Fordham Law School. She's an interdisciplinary and comparative legal scholar researching equality at the intersection of law, history, sociology, and politics, both in the US and globally. Her 2020 book, We the Women, The Unstoppable Mothers of Equal Rights of the Equal Rights Amendment, is the first and only book to chronicle and assess the 21st century revival of the Equal Rights Amendment, culminating in Virginia's ratification in 2020. And we're delighted that she is going to address us on the topic of feminist constitutionalism and economic inequality. I'm also going to introduce Professor Adrienne Stone, who will be our second speaker. Adrienne is Kathleen Fitzpatrick Australian Laureate Fellow, Redmond Barry Distinguished Professor, and Director of the Centre of Comparative Constitutional Studies at Melbourne Law School. Now, I'd also like to point out that Adrienne commenced her career here at ANU Law. Our Vice-Chancellor, Professor Brian Schmidt, constantly talks to me about how could we possibly have lost her, and what am I doing day by day to get her back. We still think of Adrienne as one of our own. She is one of the foremost scholars of Australian constitutional law, and her scholarship has a global reach, especially but not only in the area of freedom of speech. And I should say that my first introduction to Adrienne was being interviewed for the job that I have now at midnight in the UK by Zoom, and she was the external assessor, and I tell you, that's pretty formidable. Her topic today is equality and political participation, the permissive and prescriptive constitution. But we'll go first to Professor Sook, if you want to kick off.
Yeah, great. Thank you so much. I'm really excited to be here, kind of in person. I'm sorry I wasn't able to make it to Australia, but I want to thank Leighton McDonald and Dean Sally Wheeler, and I'm just thrilled to share this panel with Adrienne Stone, from whose work I've learned so much over the years. And I hope one day I will be able to join all of you in person to discuss these topics of importance. As you all know, the conference was postponed a few times due to the global pandemic, and during those postponements, my topic, feminist constitutionalism and economic inequality, also evolved. And so I'm going to begin where I began, which was thinking about the feminist flash mobs that took over the world in the fall of 2019 and 2020. That is, and there was this protest poem that was heard everywhere, from New York, at the courthouse where Harvey Weinstein was being tried, and cities all over Europe and Latin America. The protest poem begins, "Patriarchy is our judge that imprisons us at birth, and our punishment is the violence you don't see." The poem actually originated in Santiago, or in Chile, in 2019, as protest movements, not only feminist protest movements, but movements that were thinking about inequality across the board, in mass protests that began in the fall of 2019 to protest a metro fare hike, led to ultimately a plebiscite a few months later, launching the process by which Chile is now working on a new constitution, which may end up being the first constitution approved under conditions of gender parity. The poem that I referenced continues, "Patriarchy is our judge that imprisons us at birth, and our punishment is the violence you can see. It's femicide, impunity for my killer, it's our disappearances, it's rape." And then it continues, it says, "It's the cops, it's the judges, it's the state, it's the president. The oppressive state is a macho rapist. The oppressive state is a macho rapist." And what was so profoundly interesting about this protest in Chile was that they've pointed their fingers at the courthouse, at the street, and then pretty much everything surrounding them, shouting in unison, "The rapist is you." And I was really fascinated by these words and by the movements, because it got translated. And then there were protests like this in so many cities, not only in Latin America, but throughout the world. The idea here was that there was a protest against many of the things that gave rise to the Me Too movement in the United States, the violence against women, inequality. But the focus now was on not just bad men like Harvey Weinstein or even Donald Trump, misogynists, but on misogyny as a structure that should become the subject of feminist constitutionalism. So around the world, feminist constitutional movements have been mobilizing to end misogyny, and misogyny is now being construed as much more than woman hatred. And misogynists, that is the predators, like Harvey Weinstein, no longer ought to be the focus of feminist constitutionalism or misogyny as such. What I want to argue here in my work on feminist constitutionalism after misogyny is that the more often and more widespread form of misogyny is not just the exposure of women to violence at the hands of predators and woman-hating men, but the exposure of women to violence in the forms of economic insecurity and economic injury throughout the life cycle. The institutional violence you don't see, which the protest poem describes as things like impunity for my killer, like just the lack of attention to the dynamics of vulnerability that affect women, that institutional violence is actually what enables and perpetuates the violence you can see, whether it takes the form of femicide or sexual assault. American legal feminism, including the legal feminism that has been entrenched in US constitutional law, has tended to focus on the violence you can see. So the focus is on male perpetrators' wrongful and injurious acts harming female victims, and just continuing on the theme of animus and hatred, there's been a focus on harms caused by sex discriminatory acts, often by the state or at the hands of corporations. And this focus on violence, hatred, and animus tends to create a blind spot when it comes to the gains, instead of the harms to women, the gains that accrue to men and the society that they control as a result of women's forbearance or sacrifices. And so I think that the movements that we're seeing today, the feminist movements that often have taken the form of constitutional movements, driving constitutional change in various places, including Chile and Ireland. And I'd like to spend some time talking about constitutional change with regard to gender in Ireland. It seems that the dynamic is one in which there's more attention brought not only to violence and hatred, but to the gains that society extracts from women without just compensation. And so the problem is a question of women's losses and forbearance that cause the enrichment of society that we could describe as unjust, rather than the dynamic of animus and discrimination. So, so I think that should be the focus of feminist constitutionalism, and it's really important to center the problem of economic inequality, and certainly the perspective of the most vulnerable women who are subject to the dynamic that I've described. I use the term over-entitlement to describe this dynamic, which is to say that there's an improper evaluation of women's worth and contributions to the common good, which are often essential to the survival of society and the survival of future generations of the community. Here I'm talking specifically about women's reproductive labor, by which society as a whole benefit and have an over-entitlement, which is not properly recognized or compensated. And I want to suggest that this dynamic, and it draws a lot from the problem of unjust enrichment in common law, that we start with identifying an enrichment or a privilege that is caused by another party's losses or forbearance or sacrifices that gets extracted from that losing party, that is the dynamic that we should be focused on as we think about the problem of gender inequality as a problem for public law. And I think that this dynamic or this problem of over-entitlement is one that we could apply to the current controversies about reproductive rights and abortion in particular. And here, I think, just to give everyone an overview, in the United States right now, we're at a very pivotal moment with regard to the politics and law of abortion. Many states, I think some 15 states, have now passed near total bans on abortion, these so-called heartbeat statutes that prohibit abortion as soon as fetal cardiac activity can be detected, which is often before women even know that they are pregnant. These laws are likely to survive in the coming years because it's widely predicted that the US Supreme Court will overrule the longstanding precedent of Roe versus Wade, which in 1973 recognized a privacy-based constitutional right to terminate a pregnancy before fetal viability. These laws are often criticized as being misogynist in the conventional sense. They are described as motivated by hatred of women, as efforts to attack and control women's bodies, which, according to Roe v. Wade and its progeny, are subject to constitutional privacy protections. So the attack on the body that one might say is what abortion restrictions do should be protected by constitutional privacy. And indeed, in the United States, constitutional law has protected a woman's right to choose an abortion as a right of privacy, both in the body and within procreation. So US law generally insists that human reproduction is personal and private, and that state intrusion into this intimate zone is a form of violent control of women's bodies. I think that another way of understanding what's really misogynist in abortion restrictions and in these near total bans of abortion in the US and in other parts of the world is not that a pregnancy or an unwanted pregnancy is private, but actually that there's a social and public dimension to pregnancy. Specifically, that societies are often enriched and depend on reproductive labor, both biological and social, disproportionately performed by women without compensation. And so when the society restricts the possibility of women rejecting those burdens, biological and social, whether by giving birth to a child or by taking care of children as mothers, the abortion ban perpetuates the unjust enrichment dynamic. It perpetuates the society's over-entitlement to women's sacrifices and the failure to compensate the burdens and reduce the risks of maternity, which is often the case, not in every society, but certainly in the United States. The failure to support motherhood is a way also of enforcing society's over-entitlement to women's forbearance and sacrifices. So this framing that I'm describing emerges in early constitutional decisions that are contemporaneous with Roe versus Wade in the German Constitutional Court in the 1970s. These are decisions that actually strike down abortion liberalization, but ironically, in striking down abortion on demand, the German Constitutional Court, the West German Constitutional Court in 1975 recognizes that there are certainly situations, including situations in which women are in material distress, in which one might recognize an entitlement to choose an abortion. And then 20 years later, when the German Constitutional Court is deciding on abortion again, contemporaneous with the US Supreme Court's decision in Casey versus Planned Parenthood, the German Constitutional Court explains that there are situations in which exacting too high a burden from women facing unwanted pregnancies would exceed the state's power because even though the state has a legitimate interest, one which is not recognized in US law, but a state has a legitimate interest in protecting unborn life, pursuing that legitimate interest, and the state discharging its positive duty to protect both born and unborn life, if it relies disproportionately on women's reproductive labor without compensation. That poses a constitutional problem from the standpoint of what the state owes to women. And so once we understand it in that way, we can kind of think back and look at how the Supreme Court in the United States has reasoned about privacy. Very interestingly, even though the right to terminate a pregnancy was recognized in 1973, it's well known in the United States that it never amounted to anything more than a negative right to terminate a pregnancy. There are subsequent cases involving abortion funding, like Harris versus McRae, which explicitly said that there was no positive right to choose to terminate a pregnancy, and therefore the legislature could ban abortion funding, could write rules that would prevent the public funding of any abortions, even abortions that were perfectly legal and medically indicated. And certainly this idea then that there's a negative right to abortion and a negative right also to make choices about one's family life and procreation is also at work when you see the Supreme Court in the Board of Education versus LaFleur case shortly after Roe versus Wade, where the Supreme Court holds that a policy in a public school district that forces women to go on maternity leave when they're 5 months pregnant is unconstitutional because it intrudes on their choices and the private choice of whether and when and how to beget a child. But very interestingly, one question that's never raised in that case is whether or not the constitutional infirmity would be cured if, for example, the law required not only maternity leave, but state compensation of maternity benefits. That question is never asked. And then it's very interesting to note that in the abortion cases, including Roe and Casey, the US Supreme Court gets into, I mean, they think about the problem as a right of privacy to terminate a pregnancy, but at the same time, in Casey, Justice Blackmun's separate opinion really hones in on the notion that the state's restrictions on the woman's right to terminate a pregnancy implicate issues of gender equality because state restrictions, and I quote, on abortion, compel women to continue pregnancies they otherwise might terminate. By restricting the right to terminate pregnancies, the state conscripts women's bodies into its service, forcing women to continue their pregnancies, suffer the pains of childbirth, and in most instances, provide years of maternal care. The state does not compensate women for their services. Instead, it assumes that they owe this duty as a matter of course. So there, I think that a question that is lurking but never asked, definitely in Casey, and arguably also in the LaFleur case, is whether compensation for the sacrifices of motherhood, such as paid maternity leave in LaFleur, or support cash benefits for women who stay pregnant and or give birth and or raise children, whether that would in some way cure the constitutional infirmity of banning abortion. Certainly, Justice Blackmun's formulation, the state conscripts women's bodies, invites the analogy between motherhood and military conscription, and raises the question, would restricting abortion pose an equal protection problem if motherhood were valued and compensated by the state comparably to the military service historically performed by men, service which also involves risks to one's life, pain, suffering, trauma, and sacrifice, sometimes unwanted and coerced in the case of the military draft. If there existed an extensive and humane governmental infrastructure of compensation and support for mothers and children, analogous to what veterans and military draftees receive, would the government's regulation of abortion appear less burdensome and reasonably within the range of duties that fully equal citizens of a polity could be expected to bear for the public good of building and expanding a flourishing society across generations. So imagine a society, and I think with this international audience, perhaps it's easier than it may be for us in the United States, but imagine a society that supports mothers while also endeavoring to protect unborn life and reduce the demand for abortion. Compare that to a society in which the government stays out of childbearing and childrearing altogether on the premise that it is purely private. And that's to say, imagine this government doing nothing to reduce maternal mortality rates that are higher in the United States anyway than in comparably wealthy advanced nations, especially among Black women, where motherhood is a risk factor for long-term economic insecurity. Is the hypothetical society of compelled but compensated motherhood obviously less attractive than a society where the state permits abortion on demand, but does not pay for any abortions, and also refuses to provide or compel the provision of health insurance to cover contraceptives or maternity care, paid maternity leave, paid parental leave for men to relieve women of the duties of caregiving, state-funded childcare before children reach school age, pregnancy accommodations for safety on the job, or tuition and debt-free higher education, right? These questions expand the frame on what's really wrong with restricting abortion. When the state does not support maternity, including maternity health care, paid maternity leave, pregnant workers' economic security, or early childcare and education, the government fails to take responsibility for the children who will be born and raised to constitute its soldiers, workers, leaders, and rely instead on women to shoulder the disproportionate risks, costs, and burdens associated with producing the state's next generation of citizens, or as the preamble to the US Constitution puts it, our posterity. In additionally prohibiting abortion, the state coerces women's sacrifices for the social and public good. It extracts collective benefits from its female citizens without compensating them the way that the state compensates men who defend the nation's security through compulsory military service. Professor Reva Siegel has questioned whether governments that purport to be pro-life deserve the label when they restrict abortion while doing nothing to help women bring a wanted pregnancy to term. And I raise these questions now because as we are foreseeing the demise of Roe v. Wade as a model for protecting abortion access, I think it's important to engage some of the other models that have protected and evolved to protect abortion access around the world without this privacy framing of pregnancy and unwanted pregnancy, and with a more explicit recognition of both the public nature and public value of pregnancy. So, and of course, this is very interesting because in the same time period that 15 American states have passed a near total ban on abortion, many other constitutional democracies have repudiated their prior laws restricting and or criminalizing abortion in favor of safe and legal abortion access, even after the detection of fetal cardiac activities. Most notably, countries with significant pro-life and or Christian Catholic histories and populations, most notably Ireland, experienced a dramatic sea change from the constitutionally required penalization of abortion to protect unborn life towards the constitutionally permitted protection of safe and free abortion, essentially on demand, or in reality on demand, within the first trimester. And this is an evolution that was made possible by dialogue between courts adjudicating constitutional norms and legislatures implementing those norms through public policy, which paved the way to abortion access, more substantial, although far from pure abortion on demand, than that found in the places that have adopted heartbeat laws in the United States concurrently during the same time period. And it's not just Ireland. Several Latin American countries have also seen recent shifts from criminal abortion bans to constitutional abortion access, including Mexico, which by Supreme Court decision in September 2021, unanimous Supreme Court rendered a historic decision invalidating the near total ban on abortion in the Penal Code of Coahuila. And in Argentina, a statute was passed in 2020, ending its longstanding criminalization of almost all abortions by adopting a landmark law that allows women to, and any person with the ability to gestate, to choose an abortion up to 14 weeks, and also to access abortion care within the health system. And then very interestingly, in South Korea in 2019, which had criminalized abortion since 1953, there was a landmark South Korean Constitutional Court decision concluding that the criminal abortion statute did not conform to the Constitution, even though the criminal abortion statute in South Korea permitted abortions for a range of reasons having to do even with the health of the mother. It did not permit an exception for social and economic reasons for choosing an abortion, the social and economic burdens of maternity. And it was for that reason that the South Korean Constitutional Court said that the criminal abortion statute did not conform to the Constitution, paving the way now towards a decriminalization of abortion, particularly in circumstances where an abortion might be chosen because of social and economic considerations. These social and economic considerations are important. They're highlighted in the early German Constitutional Court cases, as well as in the Roe and Casey opinions, as situations that might justify an abortion in the context of a state that generally benefits from women staying pregnant because of the possibility of growing a next generation and raising a next generation, and the possibility of doing that with disproportionate burdens borne by only some portion of the population, namely women, and not others. And this framing is important because when we think about the problem of reproductive freedom as a problem for public law, I think the privacy-based, autonomy-based, substantive due process-based Roe v. Wade framing really makes it seem as though the real problem is the violation of the body rather than the lack of compensation for the disproportionate work of reproductive labor, both biological and social. And once we take this new framing of unjust enrichment or extraction of value for the public benefit as a way of thinking about gender inequality and particularly things like abortion bans, it might have implications for how we might approach the problem of banning abortion. Specifically, instead of creating bright line tests where basically the rule of Roe v. Wade is that the state has no interest in regulating abortion prior to the viability of the fetus because of the way that we understand the body to be a private space. If you shift and think of even early pregnancy as a public moment in which women are engaged in socially productive labor beneficial to the state, the frame that you might use for approaching that as a problem of public law might be more akin to takings. That is the idea that the government must compensate when it regulates in a manner that disproportionately burdens some people to the benefit of society. And certainly in the US, many commentators have suggested that the frame that ought to be used in thinking about abortion is involuntary servitude, which is banned along with slavery under the 13th Amendment. And obviously, if you think of it as involuntary servitude, one solution, although not always, but one solution to involuntary servitude is that if the labor is compensated, then that might change one's outlook as to whether it is a problem with regard to involuntary servitude, or the involuntary servitude frame might help us understand pregnancy along the lines of coerced production of things of public value, which can be remedied by compensation rather than by unfettered negative rights to access abortion. So as we turn our attention, and in just the few minutes that remain, I want to turn our attention a little bit to the developments in Ireland, by which in the period that tracks the time period from Roe v. Wade in the United States up until the present, in Ireland, there was a constitutional amendment protecting unborn life and essentially requiring the criminalization of abortion, which was repealed in 2018, after which the legislature created a framework that I think is common throughout Europe, where abortion essentially on demand is permitted in the early stages of pregnancy, with exceptions for, or rather, abortions being permitted in the later stages of pregnancy up until viability for health and wellness reasons, including mental health reasons. And so that's a real shift in Ireland that involved an amendment to the Constitution. And it's a shift that I think was precipitated in part by the public's engagement of some very highly publicized fatal pregnancies, including most notably in 2012, the death of Savita Halappanavar, who died because she was denied an abortion while she had an infection, which could have prevented her death, or the infection caused her death and could have been prevented if the fetal tissue had been removed from her body sooner. Interestingly, that episode, this kind of tragic fatal pregnancy, occurred during a time when Ireland was already engaged in a process of constitutional change through citizens' assemblies, the Constitutional Convention. And one of the questions that have been debated for really the last almost decade in Ireland has been the provision of the Irish Constitution that explicitly speaks to the unjust enrichment dynamic having to do with gender that I've been referencing throughout this talk. Specifically, Article 41(2) of the Irish Constitution, which explicitly recognizes that by her work in the home, woman, or the exact language is, by her work in the home, woman gives to the state a benefit. And as a result, there's a provision that says that mothers should not be forced by economic necessity to work to the neglect of her duties within the home. And this seems a provision that is sexist on its face, because it references only women doing caregiving work and women in the home. At the same time, the problem of amending or repealing this has not been taken lightly, because it's been widely recognized both in jurisprudence and in the discussions that have taken place with the Citizens' Assembly in the last year, that this provision forms the basis by which the state can protect motherhood and recognize the value that reproductive, both biological and social reproductive work provides to society's benefit and to the state. And so the question has become, and it's been a tricky question, as to whether how that valuing of motherhood and that valuing of care and social reproduction can persist in public law without entrenching the gender roles and stereotypes involved with assigning women that role and perpetuating it. and making it an expectation, which of course is the initial problem to which the framework that I'm proposing is somewhat of a solution, specifically the idea of taking an over-entitlement of the society to women's reproductive labor as the natural baseline of entitlement rather than an over-entitlement that needs to be overcome by public law. So I would like to stop here and I look forward to the discussion.
Thank you very much, Professor Sook. We'll take questions on both papers at the end. So if I could turn to you now, Professor Stone.
Thank you very much, Professor Wheeler, for the lovely introduction. And I want to say what a pleasure it is to be at a conference in person for the first time in 2 years, and also to share a panel with the inspirational Julie Sook. I want to acknowledge the Ngunnawal Ngambri people as the traditional owners of this never ceded land and pay my respects to their elders past and present. I also want to acknowledge the long history of excellence in public law at the Australian National University, which was the inspiration for this event. It would just take too long to mention all the greats of ANU public law, past and present, but I do want to mention too the formidable and entirely peerless Leslie Zines and the inimitably creative Michael Coper. They were mentors and later friends, and they are both very much missed. But they contributed to, I think, ANU's standing, which it has had for decades, as one of the great public law faculties of the common law world. Turning to my topic today, it has both broadened and narrowed since I first began working upon it. I began working upon it in the context of my broad comparative work on freedom of expression, but as I focused on the concept of equality, it became more and more apparent to me that Australia deserves its own focus, given the exceptionally interesting and distinctive ways in which equality reveals itself in Australian constitutional law. And I've broadened my focus slightly beyond freedom of expression to rights of political participation more generally, hence my new title. So let me say something by way of background, being aware, of course, that not everybody who is present here today, especially virtually, is an Australian constitutional lawyer. So I should acknowledge that the idea of equality appears to be an ill fit for Australia's constitution, at least if you put aside notions of equality between the constituent parts of the Federation. Supposedly a small brown bird with limited aspirations and almost nothing by way of constitutional rights, the Constitution, it appears, is simply unconcerned with the modern constitutional notion of equality of the persons. Indeed, the standard history of the Australian Constitution usually points to the efforts of Tasmanian Attorney General Andrew Inglis Clark to introduce an equal protection clause inspired by the 14th Amendment to the Constitution of the United States, which was promptly watered down and survives only as a guarantee of non-discrimination between state residents. And in the more than a century since, judicial attempts to develop a general guarantee of equality have also founded, the high watermark being the dissenting judgment of Justices Dean and Toohey in a judgment called Leith, in which they found the Constitution contained an implication of legal equality before the law, and they were joined on a slightly narrower ground by Justice Gaudron. These minority positions have never found majority support, and the reasoning is generally regarded as unorthodox. And later in Kruger and the Commonwealth, which involves no less a heart-wrenching set of facts than a Northern Territory ordinance allowing the removal of Indigenous children from their families. In that context, the High Court explicitly rejected arguments based on equality. And of course, we have in the Australian Constitution most glaringly and obviously discriminatory and frankly racist provision in section 5126, which the High Court has refused clearly to limit. So Australia is not only a constitution without a general equality principle, it contains a federal power that was conferred explicitly to allow racial discrimination. But if we narrow our focus to the political rights of Australian citizens, specifically to questions of political communication and voting, equality plays a somewhat larger role, though someone should not be overstated. And in this paper, I want to identify two ways in which equality emerges. The first form, which I call permissive equality, recognises equality of political participation as a goal that the state is permitted to pursue. The second mode, which I call prescriptive equality, recognises that some aspects of the Constitution require a form of equality even though the language of equality does not explicitly appear. And deviation from a prescriptive equality requirement results in the invalidity of laws. And the clearest example, which I'll discuss in more detail, is found in the concept of the people that features in sections 7 and 24, which, despite a clear drafting decision to leave the question of female suffrage to the Parliament, is now understood as a guarantee of universal adult suffrage that prevents unjustified exclusions from the franchise. So my theme today is to review how equality is evoked in permissive and prescriptive ways and to consider the relationship between them. There is a temptation, evident occasionally in judicial decisions and legal scholarship, to rely on the acceptance of equality in a permissive context to expand the prescriptive content of equality in the Australian Constitution. I will argue, however, that both invocations of equality resonate with Australia's constitutional and political history. They reflect Australia's history of robust, albeit flawed, egalitarian democracy and its political tradition of an activist and positive state. And these political underpinnings call for a careful balance between the prescriptive and permissive uses of the equality principle. From the point of view of the pursuit of a progressive egalitarian social order, it may be important, in fact, to constrain the prescriptive content of the equality principle. Now, the starting point for my analysis is the High Court's decision in McCloy and New South Wales, because that decision adopts an equality principle as an element of the law of freedom of political communication. The reasoning that gives rise to it arises in the context of what is known as compatibility testing. That is, the court is considering whether a law is compatible with our constitutionally prescribed system of government, and specifically whether it's compatible with the requirement that the Houses of Parliament be directly chosen by the people, to quote the most important constitutional language. Now, the challenge laws were part of a electoral funding a state-based electoral funding regime. They placed caps on donations and prevented some persons, notably property developers, from making political donations. The court upheld these provisions, and at the core of the court's reasoning are three propositions. First, that the prevention of corruption is a legitimate aim compatible with the constitutionally prescribed system of government. Second, that the influence that flows from great wealth is a form of corruption. And third, and crucially, that a law may legitimately therefore seek to, quote, level the playing field by imposing caps on donations. It is this aspect in this last aspect of the reasoning that ideas of equality emerge. To quote the joint judgment, equality of opportunity to participate in the exercise of political sovereignty is an aspect of the representative democracy guaranteed by the Constitution. So, the role of equality in McCloy is twofold. On the one hand, it justifies a limitation on political communication. But on the other, that limitation is seen to pursue the very same values that the freedom of political communication itself promotes. In other words, it enhances political communication, although in some sense it is a limitation on political communication. Now, the acceptance of what I call the enhancement rationale for limiting freedom of expression places the High Court of Australia and our law firmly in the mainstream of constitutional jurisprudence internationally, and you could look, for example, to the decision of the Canadian Supreme Court in Harper and Canada, and to the decision of the Supreme Court of the United Kingdom in the Animal Defenders case for similar kinds of reasoning. So it might seem unexceptional and perhaps to Australian ears totally unsurprising. But if you spend a ridiculous amount of time steeped in free speech theory, it is an arresting proposition, or at least an important one, because the approach in McCloy stands in stark contrast to First Amendment law, which, though exceptional in world terms, remains intellectually dominant in free speech theory. And First Amendment law does not accept the enhancement rationale at all, an approach usually traced to the Supreme Court's decision in Buckley v. Vallejo. In that case, the Supreme Court refused to limit expenditure in the context of campaigns because those expenditures, those limitations could not be justified on the grounds that they levelled the playing field for participation. In what Justice Brett Kavanaugh has called the most important sentence in First Amendment campaign finance law, the Supreme Court said the concept that government may restrict the speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment. So McCloy is significant because it places Australia on one side of a deep schism in the theory of freedom of speech, and a very important decision because in fact in earlier law there did seem to be some flirtation with First Amendment ideas, and McCloy puts the question to bed. It is therefore a clue to some of the deep values of the Australian constitutional order. Now it's tempting, and given my topic today is equality, it was tempting to seize upon this as evidence that we have a difference between two central liberal values, liberty and equality, and then to characterise First Amendment as a sort of liberty-based tradition, and Australia has adopting a kind of equality-based tradition. The position is in fact quite a bit more complicated. Throughout the law and theory of freedom of speech, equality acts in fact both as a limitation on freedom of speech and as a way of justifying it, and that is evident in the theory of the First Amendment itself. There are both non-consequentialist and consequentialist arguments that justify that First Amendment refusal to allow the levelling of the playing field as itself driven by equality concerns. I have elaborated this argument in great detail elsewhere, and I'll say relatively little about it just now, except to say that it is evident that Australia does not adopt the argument that is, for example, associated with Robert Post, that formal equality to speak as a mean of ensuring autonomous self-expression and self-development is a necessary precondition for freedom of speech, nor, shifting tack for a moment to consequentialist forms of argument, does it share the belief that drives First Amendment law that all regulation of expression is inherently risky, given that the state the regulation by the state will be deployed in ways that are self-defeating or worse, serve the interests of the state. So the significance of the adoption of the enhancement rationale in Australia is really to indicate that the Constitution is premised upon a permissive attitude towards the state regulation of expression. That is, the Australian law of freedom of political communication does not share the high degree of mistrust of government that characterises First Amendment law. On the contrary, it accepts that, in some circumstances, and subject to a proportionality test, the state might be a good faith actor with a legitimate interest in limiting political communication for reasons of equality. Now, the acceptance of the pursuit of equality as a legitimate governmental objective resonates loudly with Australia's political history and tradition. The Constitution is aptly described as modest compared with almost every other extant democratic constitution. It does operate over a narrower field and has a fairly limited transformative ambition. But as scholars of the Constitution have long noted, there are respects in which the Australian Constitution was for its time and continues to be progressive. Now, a careful review of the history would take much longer than I have here, but a few features stand out, and let me note that this account, which will ultimately be given fuller explication. I should note the influence of some important historians of Australian politics of constitutionalism, including John Hirst, Helen Irving and John Williams, as well as a wave of really exciting and important new writing from William Bartlett, Lindsay Bladen and Patrick Emerton, among others. So there are a few features of this history that stand out. One is a very robust conception of the franchise. From very early on, despite the framers' refusal to preempt the issue, white Australian women were conferred with the right to vote and to stand for Parliament in 1902, even earlier in some states. It is combined with a conception of a very powerful and active state that would act in the interests of people, of the people. And the two are, of course, related. It is precisely because of the breadth of the franchise that the people can be persuaded to accept the majoritarian processes that will be responsible to the people and act in their interests. Now, this attitude towards state power, I think, often surprises non-Australians, who I think have a conception of Australians as rather resistant to authority. In fact, I do remember American colleagues saying to me that they always thought Australia was sort of like Texas. When Texas is a wonderful place, but nothing could be further from the truth with respect to the attitudes towards state power. In fact, the sort of cultural contradictions were captured by John Hirst in his memorable description of Australia as a nation of obedient larrikins. Right? Larrikin being a sort of Australian word that maybe most closely aligns with something like maverick, but it captures the idea of a person who's very unwilling ever to confer respect individually on your leaders. You know, as Australian constitutional lawyers will know, resonates very loudly with a decision like Coleman and Power. But they are obedient in the sense that they are remarkably willing to accept state limitation on their personal freedoms, which we've seen just so very vividly in the context of the pandemic. And strikingly, that willingness to accept compulsion extends, as John Hirst emphasises, to the very process of the formation of government, with compulsory voting as a long-standing and relatively uncontroversial feature of our politics, but entirely unusual in world terms. So we have an exceptional, rather combination of fierce egalitarianism together with a willingness to accept state interference in our lives. Now, in case you think I've donned a pair of exceptionally rosy glasses, there is an important qualification. Although Australia has long had a relatively wide conception of the franchise, evident in what Elisa Arcioni has called a strongly demotic conception of the people, the highly exclusionary and racist attitudes towards the franchise are a crucial flaw. It underscores the point that a history of racial exclusion and non-recognition of the prior political communities of First Peoples is still the most important unfinished business of our constitutional order. So to be clear, I advance this not as an uncomplicated celebration of Australia's political traditions, but a way of making sense of the permissive invocation of equality. In the context of a progressive, if critically flawed society committed to the pursuit of social goods through majoritarian processes, it is entirely fitting that the pursuit of equality by the state is a legitimate end in constitutional terms. So thus far, the role of equality as a constitutional principle governing political participation is relatively weak. The state is permitted to pursue equality, it's not obliged to do so. And on one view, equality would be of more significance if it operated to constrain rather than simply to permit government action. And there's clearly a possibility in Australian constitutional order that this can occur. I mean, as Ryan Goss has recently reminded us, all Australian parliaments are subject to entrenched, judicially enforceable constitutional restrictions on the substance of their powers. We are not, in an uncomplicated way, a system of parliamentary supremacy or sovereignty, but rather a constitutional system with more than 120 years of final constitutional review enforced by judges. To put it another way, despite the Australian commitment to majoritarianism, we have a long, deep, if narrow, tradition of constitutional review. Now, the possibility of equality as a prescriptive principle emerges from another number of decisions, but my focus will mainly be on Roach and the Australian Electoral Commission. Roach is a case which addresses the vexed questioning that all constitutional courts seem to have to face at some point around prisoner voting, in which the High Court rendered invalid an attempt to impose a blanket ban on prisoner voting, instead reinstating what had previously been a ban on voting by those serving a sentence for longer than 3 years. The judgment contains important analyses of the nature of the federal franchise in generally, and importantly, have majority for the proposition that the words sections 7 and 24, that the people be directly chosen by the people, presumptively requires universal adult suffrage, and exclusions from the franchise must be justified by a very substantial reason. Now, the judgments in Roach do not directly invoke equality in those terms in support of this decision, but the idea of equality, and specifically of formal equality of political participation, are obviously at their base. Significantly, as I have already mentioned, it flew in the face of a very deliberate decision of the framers to leave the question of the female franchise to the Parliament following during Federation. Roach is therefore a case in which the High Court recognises a change in constitutional meaning over time. At the time of Federation, directly chosen by the people did not mean directly chosen by the people in the sense that it included women, but it now does. It also now precludes, it probably didn't at the time, as the dissent of Justice Hayne makes clear, it also precludes a blanket exclusion of prisoners from voting. Now, the reasoning of the case is highly attentive to questions of interpretation. The idea that the meaning of concepts in the constitutional text might change over time is mainstream, and the judgments, notably Chief Justice Gleeson's, rely heavily on techniques of long-standing to achieve this result. Justice Gleeson draws a very direct analogy to the changed meaning of the words foreign power in section 44 of the Australian Constitution, which is Australian Constitution as well known, at the time of Federation did not include the United Kingdom, which was not foreign to us, but now does, given the change in facts in the world in the intervening period. So in relation to directly chosen by the people, what has changed, in the words again of Justice Gleeson, is the widespread, long-standing fact that the franchise has been extended to universal adult suffrage with attendant change in the meaning of directly chosen by the people. But in addition to this traditional form of interpretive analysis, and especially in the judgment of Justices Gummow, Crennan and Kirby, Australia's political history comes to the fore. After a long review of the history of the franchise, and relatedly of qualification and disqualification of candidacy for elected office in the Australian colonies, the joint judgment concluded that as a matter of practice, the Australian colonies, pre-Federation, had a rather more inclusive approach to the franchise and eligibility for office than existed at the time in the United Kingdom, and that disqualification from the franchise and the eligibility for office turned at that time on conviction for treason for a felony. So here there is reliance on a distinctively Australian practice with respect to the franchise to justify the conclusion in Roach, expanding and frankly reorienting the concept of the franchise to include an equality principle. Together, these allow for the reinterpretation of the principle of the notion of the people to apply in circumstances that would not have been envisaged by those who drafted and adopted the words. Now, let me turn then to consider a little further the relationship between prescriptive equality and the Australian constitutional tradition. Now, Roach shows that the distinctive Australian approach to the franchise can affect what the Constitution prescribes. So our political history is relevant to what the Constitution prescribes, not just what it permits. So our political history in this sense is an interpretive resource that informs the meaning of constitutional text and structure. Now, there are some aspects of the reasoning in Roach that are a little bit unusual. The changed facts in the world in this case were what Justice French in an earlier case called durable legislative developments. But in the end, it is, I think, reconcilable with constitutional orthodoxy. And so Geoffrey Goldsworthy, who has articulated by far the most powerful defence of the High Court's interpretive originalism and formalism, has accepted, albeit under some pressure from Patrick Emerton, I have to say, he has accepted the orthodoxy of the Roach reinterpretation of directly chosen by the people. But we need to think, what else might this prescriptive equality principle mean in relation to the franchise? And let me offer a couple of speculations. To be clear, these are not predictions. I am not predicting that the High Court is likely to expand the concept. I'm exploring the limits of this form of argument. It struck me, for example, that perhaps compulsory voting might be recognised as the kind of durable legislative development that now forms a constitutional baseline from which the Commonwealth cannot depart, at least without a substantial reason. The argument might also lead to a reconsideration of cases like McKinley and McGuinty, two cases in which the High Court of Australia has refused to accept that the Constitution requires equality in electoral size as a result of the provisions that the Parliament is to be directly chosen by the people. So it allows for a degree of malapportionment between elections and has declined to adopt an equality principle in those circumstances. If we allow ourselves just the indulgence of a little bit more constitutional imagination, perhaps it might form the basis for an ideal of equal citizenship as a precondition for a form of representative government that might have implications for the way that citizenship law operates, and that is especially topical just at the moment. Now, these are possibilities that I think this form of reasoning suggests, and they might sound very attractive, but I want to sound a notion of caution, a note of caution. They're not obviously good public policy. In particular, the idea of overturning McKinley and McGuinty might raise some worries. Is a highly prescriptive equality principle in relation to the drawing of electorates appropriate in the context of the continuing contestation of the competing political sovereignties of the Australian nation and its prior political communities, the First Peoples? I know that in this latest round of reconciliation and recognition politics that the idea, for example, of Indigenous seats has not been part of the demands of Indigenous people, but would we want to exclude that for all time with a prescriptive equality principle? This kind of rigidity brings me to my final point. Whatever the case is for a robust Australian equality principle, there would be an irony if the argument for one proceeded in the way I have just described. The argument that founds a recognition of a robust and prescriptive equality principle is based at least in part on the idea of a constitutional tradition. Now, I'm invoking a large concept and can only say a little bit about it, but I want to say that these arguments are drawing their first in partly by appealing to long-established practices with respect to the franchise. And the appeal of these practices comes from their appeal to the past and their continuation, subject to gradual evolution only into the future, and to their identity with the Australian polity. So they are our practices adopted long ago, continuing into the future, and they're ours. I think that's the normative appeal of them. Now, understood in this way, the Australian constitutional tradition also includes a commitment to political constitutionalism. That is, to a preference for some questions, especially rights questions, to be decided by political, not judicial means. And this aspect of our tradition is clearly linked to the idea of a progressive positive state. The relatively limited nature of the prescriptive constitution is precisely what opens the way for a progressive positive state to pursue its goals, including its equality goals. So whether Australian constitutional law needs a revision to better pursue equality through a strongly prescriptive principle is an open question. But, and I have not sought entirely to defeat the argument here, what I do want to say is too quick an argument that the possessive egalitarianism of our history allows for the expansion of a prescriptive constitution risks the very progressive constitutionalism and strong egalitarianism that is the finest strand in our somewhat mixed constitutional history. And that's all. Thank you.
So thank you very much. I think everyone would agree this has been a great first session to kick off the conference. If we could thank both speakers in the usual way before we go on our coffee break, that would be great. So thank you very much.